How do you are going to the judge and remember all the numbers? There are one. Yes, I think clause 89, AI provides for that.
Yes, that's it.
So why you are not taking a decision on the bills
Sir,
of estimation?
actually, on 22nd 9 2025, we sent a letter to them. They have to take a call on that. They have never responded.
What
25
call?
only. Now it is.
That's it.
Now 1 year has passed. Literally.
Let them submit the documents immediately. That's it.
Is it a 2026, sir? Oh, Achana. They wanted a labor license certificate.
We are not receiving. I will submit all the documents. Same other Vidyalaya, different agencies are allowed. Only
We are.
Yes, yes. Yes.
Yes. Whatever, doing for the state,
No. Never began.
where is the? Where is the Union of India? Have you served the copy on the office, is the office of the DSG?
Yes, Your Lordship, on 23/2026. The March.
Small matter, unnecessarily it is getting delayed because they are not appear. Where is Mr. Where is the London DSG? Is he online? Obviously.
Yeah, not China.
He has not joined. Can you go and call him? You are making a call for him. Call him.
Item number 3.
Item number 2. This morning itself, I got instruction from workers that is.
What you were doing while you were sitting?
I was making sure because the cause is not.
You don't carry a brief because you always believe in that.
Because my lords, we do not have the brief right now. This morning itself, I have got instructions that workers is in this as opposite party number 2 to 5. So I do not have any
What?
brief right now.
What?
Opposite party number 2 to 5,
Uh-huh.
workers has instructed me this morning itself. I do not have the brief that such and such matter has been listed. So that is
Who
why
is responsible for payment?
Yes, for the workers. So let them have a copy of the petition, my lords. I take instruction and file wakalatnama.
Keep it on the next week.
Man.
See that the money is paid.
I'll balance. It's just move to the brief.
There is no dispute raised by you ever, not a single letter according to him has been received. Then you are
I'll look into it.
What's your good name?
Anish Ankur Mishra.
You will be
Yes,
signing the
yes,
work
yes.
appears on behalf of the.
Functional already become.
Just 1 minute. Let me refresh.
Yes.
What is this rate contract?
Rate contract is normally for those items where the government forms a policy to include only the MSME industries, and they will provide a rate which will be applicable for the year round.
Okay.
So whenever a supply is made on rotation or random,
supply.
yes.
Yes, that's.
So that rate is fixed by the government every year.
Tender.
Yes, rate is fixed by the government every year.
So.
And all these MSMEs.
So your condition is that book item which is to be.
No, I am appealing for the opposite parties.
I know that must conform to certain specifications, which includes BIS clarification, which is still not there.
Which is still
That is what they are
It is
saying.
not there. You said that you are a manufacturer.
I am
having,
also
everything, but you have
supplier. I am a supplier. No, I have not been deprived. I am one of the suppliers. OP number 4 and 5.
Yeah.
We are the suppliers, and that supply has been completed. Period is over, and no further renewal has been made.
I think you have made out a case on that being a qualified manufacturer was denied and your opportunity to participate in the tender.
I am for the opposite party.
Oh, you are, sorry.
My
Yes,
last name is for the petitioner.
So you do not have a BIS clarification.
That's what they say.
Yes, Your Lordship. It is still pending. Our senior was supposed to conduct this matter, but due to some personal difficulties
Who?
available, our senior, your lordship.
Who is your senior?
Amitabh Das, Mr. Amitabh Das.
Senior counsel. Senior counsel, Mr. Das, Mr. Amitabh Das.
1 week's time to be granted, your lordship.
What is the good name?
Anshuman Das.
Government has already clarified in their counter. Let it come, absolutely. Not any day.
Item 4.
Period is over, so the stakes have also.
Your Lordship, I'm appearing on behalf of the petitioner.
Where you are appearing?
Your Lordship, apologies, I'm appearing from Delhi through VC.
Any of?
I apologize for the
Who
inconvenience.
is the opposite party?
Your Lordship,
Who are the opposite parties? Vision Group Company.
Bridge and Roof Company, Your Lordship.
Notice. 3 weeks.
Much obliged, Your Lordship.
Item number 5.
Just wait for 1 minute.
I have a limited
That's a way to comprehend this particular expression, the exact meaning thereof. The word is historical document. What does it mean? I understood the historical document, something else. Then a work experience, the other, whether that they constitute a historical document. I am unable to comprehend this expression. What is the meaning there? Lordship, his historical meaning was.
Lordship, past experience it comes
It's
with
not this is another thing. Historical means it has some certain incidents of important which augments in the country having attached to it. That's a historical.
historical, Lordship. But there is that what mean there by
I do not know historical. What is the meaning of the word historical document?
That actually the meaning is that lordship is wrong.
But what
It
is
is
this?
used in other way here.
Why?
It may be historical for the department that's.
Historical for the department. A work experience is issued, work experience certificate is issued. In a very recent time, it becomes a historical document. I do not know, I have just had to understand the meaning.
Preceding 5 years.
Clause 8.55.1, it talks about that if there is any ambiguity or confusion, then you could have asked for a clarification. How can you proceed to reject the bid? What is the tender for?
Tender for construction of the Lordship.
Correct. Both then, a one post will be kept vacant according to you. What is the interest rate?
Then sir, extremely sorry, but go through Lordship.
One post to be vacant.
Lordship.
Which post? Tell me.
Extremely sorry, Lordship, that is
Sorry.
you do copy paste my name.
Oh.
Extremely sorry, Lordship.
What is the force which is in respect of a subject tender? Come to clause prayer C of the writ petition, interim. Post slash work. So what is a post?
One post of contractor.
No, Lordship, that should be deleted. Sorry, Lordship, it happens sometimes, Lordship, due to,
Happen?
that is our error, Lordship, that is.
How you can? Why you did not ask for a clarification?
That, I have instruction in this matter.
Yeah. There is a format one.
But lordship, shall it on to page 49. 49.
Yeah. That's reaching. Yes. Has he furnished the certificate?
Lordship may see they have only furnished the
The
document.
running bill,
Yes, Peter, page 70.
RA bill, I think.
Yes, Peter, page 77.
Yes. No, 77 is a condition. What is this?
Let's,
The conditions for working as security.
the array bills, sorry, it's at page 91, 91, 92.
The running account bill.
And 83 also, 84 also.
Yes, Mr. Godoy.
Lordship.
If a particular document is to be annexed as per the format, if we have not annexed,
I have annexed, Lordship, but instead of the certificate, but signed by the executive engineer, the same contents, but in format, Lordship, which they have written in the tender, that was not the Lordship, that I have not submitted. That's why, Lordship, I am going 8.51K may come to my rescue, Lordship, because it is a competitive bid, Lordship. This technicality should not, Lordship, come on the way, while, so Lordship, only my submission, only they will take a decision only in view of the clause
no,
8.
they have already taken a decision. We have to upset the decision.
That's it, there.
Here is at 8.5.1. Yes,
That's the order is that, in that.
I know.
Second file.
This one is it, gone.
Connected on the.
Only difference, Lordship, that judgment came out when the tender already completed, Lordship. But in this case, I have approached prior to Lordship tender. The ratio is same, Lordship, I will not.
Yes.
Ratio is same.
If the format is, had there not been any format,
Lordship.
I would have understood that what is required.
Lordship.
If you do not follow
No,
the.
immediately I have, Lordship, I have submitted. That is my case, Lordship. I have submitted all those documents, Lordship, because Lordship sometimes happens to the contractors, Lordship, because there's voluminous, Lordship,
Is
DTC
there
and
any provision that the document which is not included in the bid can be produced before the evaluation?
no, that's why I'm saying 8.5.1
Yes.
may come to my rescue, Lordship.
Yes.
Lordship, that's why.
It is after the opening of the technical bid,
Lordship,
the bidder may be asked. in
may
writing.
be
So-
asked in writing.
Yes.
So Lordship, that is their discretion. They have not asked me. it could have been resorted this clause. Yes.
Clarify on the uploaded document.
Upload document.
Provided in the technical bit, you have not provided the certificate.
I have uploaded lordship. Instead of lordship,
Certificate,
yeah, certificate.
have you submitted a certificate?
No.
No. If it is not, then
That is my
they
case.
have said certificate, not the article.
Lordship, last two matters dismissed lordship. Same view. So only what?
What is a sauce for a gander is a sauce for a goose.
I was expecting lordship if they have not.
No.
That's enough. I was expecting lordship if they have not taken decision, then could have been given a direction.
The petitioner has challenged What is this, 433?
Both the matters, Lordship.
Page 253.
250.
250. Lordship, both the matters same, Lordship.
Ah.
Only Lordship, instead of decision, that is procedure to participate in online bidding is recommended. Correct.
Yes. Next.
Item number 6.
It's for the minister.
Item 6.
It's a good case. Two thousand six judgment, 2016 judgment. 2006 judgment is of.
Regarding that.
Paragraph 79. 2006 was in SSC.
So there are only 9 ones. I am finding 9 items have been posted.
Yes, Mr. Because 101 bidders they participated. 100 bids were disqualified. Only one bidder emerged. How can you proceed when it is the last number of the people they participate?
That is not the case of the Lordship of Congress.
This is not the case. Without 101 bidders, 100 you have disqualified.
Kindly.
One bidder you chose and proceeded to award the contract.
There are 2.
What is that judgment? 2006 volume 10 SCC. This is Messiah's judgment. If I remember, paragraph 79.
Here the case is absolutely different. Well, Lordship, may kindly see para 5.
You don't have.
Lordship, may kindly see para 5.
What is this?
Is the instructions which I have received. Para 5, your Lordship, may kindly see.
How many bidders participated? You just tell me.
But that is what I am saying, man.
Yes, tell me orally.
But 101 bidder participated.
How many bids were rejected?
But out of whom 6 bidders were found technically qualified.
Okay.
Of these, 3 submitted financial bids and all
3 submitted financial bid.
Yes.
Out
6.
of 6, only 3.
3 submitted financial.
Then how you have qualified even at the technical bid stage if they do not, it does not contain a financial bid?
But technical bid only 6 qualified. 6 out of 101, 6 qualified.
So 3 were there.
3 were.
Sir, what is this? Your case is based on.
My lord,
Your case is that 101 bidders they participated, 100 bids were rejected, one
Only
bid
one.
qualified, and the contract is awarded to you. That's your case. Total.
the unnecessary as I have filed the unnecessary 3 multiple.
No, what else is your case? Whether it is only one bidder or
Only one bidder. Only
How
one
can
bidder.
it? He says 3 bidders. He says 3 bidders, sir. 3
But I
bidders
have filed
were
only-
there, and out of 3, one has been chosen.
Minus page 44 kind of thing. Serial number 88, my lord.
Huh?
Serial number 88. Page 44, serial number 88.
Huh?
That is only the Jagannath put and that is the only qualified. All are disqualified.
So it has to be qualified. He is to be qualified.
Only one is qualified.
Yes, he cannot be rejected.
Or
He
others
cannot
are
be rejected. They do not have the so much dare to reject it. What is the name of the qualifying bidder? What is the name?
qualified medical is the unnecessary.
What is the name?
name?
Jordan C. Jagannath products
Sri Jagannath
and the research and the
properties.
Can they reject with this name?
no.
No. Rightly qualified. Yes, this document, sir, this document shows that he is relying on, all are disqualified.
All are disqualified.
Sir,
Instruction.
I do not know.
Then I'll have to
You downloaded it from their,
Online.
let them put this by open affidavit, whatever they have said, I have. I'll put it by the.
if you have uploaded, then,
There may be some other documents that is not there in the writ. I'll produce by.
the
Item number 7.
My lord, appearing through VC, my lord, seeking permission, my lord.
just give me one. Oh, again, I think all your matters are concerning below 15 or above.
My lord, my lord, I'm so sorry, my lord, I'm getting only this type of matters.
Do not involve this.
My lord, the problem is, my lord, in fact, my lord would see page 8. I think, my lord, even the L1 is disqualified. He's not, his beat is not responsive. Page 8, my lord.
Yes, what is this? Now you have made an amendment. I do not know whether it was floated after the amendment or before amendment.
But these are before, my lord, before amendment, my lord. Amendment will apply after January
You
26.
have recasted it now 15% criteria has gone.
Yes, my lord.
After.
That 14.99 criteria is not no more there.
That is what I'm saying.
Yes.
This was floated before or after?
Before.
Before.
These all before, my lord. These all before.
Yes, sir. Come to page 8.
Page 87, your lordship may kindly see.
Not 8.
87.
If you come to page 8 first. The table.
But in the table, my lord, BKD is exactly 15%. So bid must be less than 15%, cannot be equal to 15%. So this bid first, my lord, L1 is non-responsive.
So now you take me 87. Give me 87.
So in fact, the one BKD has already been disqualified.
Then
That is the exact.
qualified.
Then the
Did it-
next is the
The second.
The
He
second
knows
is-
minus.
No, he is above.
No, he says minus 15%.
No, if your lordship should read the amount, the lordship should see the amount, there is a difference. Maybe 2 rupees or 5 rupees, but it is above that.
It is 58 and that is 60.
1 rupee, 5
One,
paisa.
but that crosses it, makes it below 15. That is the exact 15 is the first one, BKD. That is why he has been disqualified.
Minus.
So they have rounded up to 15%. And the original, my lord, this is just the.
What you are taking now?
If your lordship should see.
I understand. You are successful.
Yes, BOQ is missing in the writ
We hear the
petition.
state first.
The BOQ is missing in the writ petition when they have challenged it. What is the original BOQ? They have given the first page at page 228, but the second page has not been given in the writ petition, which we have just forwarded to your lordships.
What is this? Now, first, let us see page 87. What is this?
Page 87.
Yes,
This is the condition which was incorporated by your amendment in 2023. Now, my lord, may kindly see the condition.
What?
If the rate quoted by the bidder,
From where you are?
page 87, section
the
2,
rate.
17.2.
Correct. Yes, 15%.
15%. If the rate,
Less than.
yes, less than 15% of the
Will be
amount,
rejected. That is the very formal one.
yes, and the tender shall be finalized based
So
on.
then it is, if it is less or above, let us see. That is what I'm saying. Here, this clause, everybody is relying, even a petitioner is relying on this clause. But now he has given a comparative chart where he has calculated what
That is
you have
what-
to say about
That is what he has given,
Correct.
but
What is your stand?
But that I have to get it from the authority, because what would be the threshold amount as per this 15%? Now that threshold amount will be the determining factor. If whether somebody has
It's the
paid-
same price. What you are saying, L1 is given, he has quoted the same price which is given.
No, my
What
lord,
is this about?
Percentage is missing.
Oh, he has given a percentage that if this amount is quoted, then it will be less 15%
No,
of
my
the
lord.
estimated cost.
But it is not. Even that 1 rupee
Then
changes
there is a
that to a
mathematical
fraction.
calculation.
It
You
is
give
more
a fraction. If their mathematical calculation is wrong,
that-
difficulty.
that I'll produce, my
It's a
lord.
very
That I'll
open
produce.
case.
Your lordship may call it next week. I'll produce.
It's a very open case.
Yes, ma'am.
Nothing
Yes.
more than that.
We'll give the calculation.
And
They
another.
have to give a calculation. Your mathematical, I think your statistical expert has not done it properly according to their.
Yes, sir.
And one matter, today your lordship have reserved for orders. Your lordship will pass caprice for passing of the order. That is Ajodhya Sagar. Last week your lordship heard that matter.
Yes,
We
yes.
have filed the counter affidavit. Identical case. Same matter today.
Item 23, my lords.
That would be the
Item number 8.
Deeply obliging.
In this item, my lord, 7, my lord, the BKD has already filed a writ petition. This honorable court direct to take instruction. Mine says exact 15. They may be tagged. My lord, I have not even disqualified till 8, my lord. There is no disqualification order.
Disqualified.
No, it is not disqualified order. My lord friend is appearing, but let me along with that. Is 17742.
Item 8.
So, Lordship, may kindly call it next week. I filed an IA.
What for?
Some amendment.
Amendment. It is submitted by the. Just.
Sir,
Have you given up?
No, that's he has been awarded the work, my lord. That's not.
Blacklisting gone.
Yes,
Everything gone.
He has been awarded the work, my lord.
Panda infrastructures, there are many judgments on the. What?
I don't know, because now my friend is saying so, I believe.
Would you like?
In your brief,
The British
Item number 10.
Again, of factual aspects are minus 15, more than 15, 0 or 1. What is this?
7.
Mr.
No. Yes, sir, that is not the case, but they are saying,
This is what a case.
they're saying,
They have said that it is for a construction of a 50 MT godown
Yes,
of a
yes.
building.
Yes.
At PSC
Yes.
in the GP Gujanga. You have rejected his tender bid.
I became the
Despite being the lowest bidder,
Yes, ma'am.
it was shown as non-responsive
Yes, ma'am.
on a technical ground of deficient clause 8 and 9.
8 and 9.
Yes. That now you have opted for a lottery system.
Yes, ma'am.
Other bidders who quoted 000.
Yes.
So the competitive price.
So therefore, ma'am, they have gone for the lottery.
This is after the amendment or before the amendment. 15% cap. Why you have shown is non-responsive? What is the ground?
Ground is deficient 8 and 9, but my document I have filed annexer 3 series. I have filed those documents. That is before Lordship. Your Lordship might find
whether those documents forms part of their bid.
yes,
Lords have taken instruction, it doesn't, Milord. And there is
So
a.
you have to say this is a factually you have to deny.
Yes, Milord. So, Milord, I'll affidavit. Milord.
Affidavit is in a week. It is submitted.
Item 11.
Just give us one. We are heard otherwise. You are going too technical, but we are heard otherwise. That this clause is discriminatory in nature. You cannot restrict it to a particular juristic person or an entity. Only to what we put.
if actually votes then if otherwise.
I think both of you in one matter where you have excluded a proprietorship concern.
Yes.
We have heard that it is violative of Article 14, but correct me, remember?
Yes.
We have already heard that. And we said that they should be permitted to participate.
Yes.
If you include a partnership firm,
Why not a proprietorship?
when two persons, how can you exclude a proprietorship concern?
But I am
One means a partnership firm, which is more than one.
right. That's right. That is the
Then how
definition.
can you exclude the proprietorship concern, which is
So I don't know what has happened
Where is
in
the
that
judge?
matter. If at all that particular clause was under challenge in that case, where your
It
lordship.
was there. It was challenged. We issued a mandamus that if you can't restrict.
So here the clause is nobody challenging the clause. But kindly-
Proprietorship concern has been
It is
given.
there, my lord.
No, no.
In fact, in this very case also, proprietorship is allowed. If my lord will see page 69. Page 69. Which is format, which is my lord,
No.
that
He
here.
is going by the terms and conditions.
Yeah, my lord, this is also part of the tender document.
Oh, whatever, it is inconsistent then.
What is this?
What is this?
Tender for origin.
It's a format.
T3.
My lord's T3, my lord. My lord, that four, my lords, type of firm. They say private limited, public limited, and then proprietorship is also there.
Where is the proprietorship?
My lord,
Oh, proprietorship.
yes, my lord. So it is there, my lord. So that is why, my lord. That's
Mr. Roth.
Yes, please.
Yeah, we had.
Lord, I'll definitely
Yeah.
bound by your lordship.
Yeah, we had Article 14 violation. You know the law.
Lord, I know.
You can't stand it.
Lord,
Had
there,
it not been a firm, we could have done it because that's a different position, but still, we haven't done.
can I check up that judgment of the lordship? Let me check it up. I'll take help of planet friends if they can provide me.
I think either of this, either Miss Das or Mr. Das, either of them.
Lord, whatever your lordship has been pleased to hold, I'll be bound by that. Certainly, I'll not go beyond
You
that.
know the law better.
Yes,
from
Lord,
your
I have come with certain judgments also, but then if a lordship has been pleased to hold it, Lord, I have come on the point that there is a distinction between a farm and a proprietorship concern.
No,
If a lordship sees the latest law on this,
no.
if I can show you a
What is
lordship,
the proprietorship?
else.
There is the distinction.
Yes.
If is always used in a sense.
But it's only for
The
academic
business
purpose,
is
not in
being
the
carried on. The business is being carried on by more than one person in a compendium name.
That's a farm.
That's a firm.
That's a farm.
Proprietorship concern. there is
Individual
singular
concern. Individual
individual
concern.
Who is running the
In
business.
the name of individual.
That's why the word firm and concern.
Concern,
is
yes.
different.
Kindly similar, this judgment speaks about that only. Only like give the distinction. Kindly similar. This judgment,
Very choosy.
your lordship judgment
That's
is also.
why I always use the
But
word concern.
but your lordships are more accustomed, acquainted with the other high court. But these things often your lordships must be facing there. I know, but this is also the ratio. Whatever your lordship say, this is the judgment passed by the Honorable Supreme Court. Still, if a lordship has been pleased to hold that proprietorship concern also can participate despite this term, but I will be bound by it. Certainly, I can't go beyond that. Kindly see para 4.3.
4.3.
Yes. The Order 30 Rule 10 is taken note of here. Here, in that suit, in the suit, in this case, in a suit, a proprietorship concern is substituted by the proprietor name, by name of the proprietor. This is arising out of a civil suit.
Oh, that's why.
Yes.
I understand.
Arising out of a civil suit.
Why? Because once I see Order 30, then I say how
Order
the
30 Rule 10.
partnership firm has to be represented.
Order 30 Rule 10.
I know these are the provisions.
Yes. But still, then will be bound by your lordship view. Lord. I will be bound by.
There is a distinction, no doubt.
Let me.
But you can't restrict the open.
Let me go through your lordship. Let me have a look over there. I'll come and tell that your lordship judgment will govern the field.
Order 30 that have to be the partnership firm has to be disclosed.
And if your lordship says,
The partners have to be disclosed.
Assault Transport Agency also speaks of the same thing. That is the same thing what your lordship said. But still then let me go through the judgment of your lordship judgment. I'll come back with agreement with your lordship view that instead of passing an order, let it be adjourned to next week. I'll go through in the meeting.
Because the proceeding, once it is filed before the board, then the procedural law which governs and regulates the proceeding, that has to be followed.
Your lordship.
But in an administrative side, when you restrict or exclude any juristic entity, I'm against it, not I would say the
Proprietorship.
no, I'm saying not
Restricting
the
competition.
living entity.
Yes,
The juristic entity. Then in that event, how can you exclude one entity?
But in that case,
From participating because
minimize the
then-
competition.
Then it offends
Yes, yes.
91 clause, the article 91, right to trade and the profession. I think G is the correct.
G is the correct proposition, not
So how can
provision.
you restrict?
But in that case, they should amend this tender
I
clause.
have already held in that and I give the mandamus
They should amend it.
that if they have included.
They should issue a corrigendum to that. That farm, this proprietary concerns are also allowed. They should issue a corrigendum.
If they're challenging, they have participated.
No, sir. That mandamus was open one.
Yeah,
The court has held that it is discriminatory. You cannot eliminate.
that will be a judgment in rain. Yeah,
Because,
judgment.
offending Article 14.
They should issue a corrigendum.
Then how can you continue with this?
Yes, they should issue a corrigendum. But I don't want to restrict the competition.
Like I showed, Miller, there is in that T3, Miller, there is the provision there for any party.
That's a consequence of a tender condition. That's not a tender condition.
That is part of the tender document, Miller. That is the format in which the bidder will apply. So
He should not justify it.
Then we go into another nuances of it. If there is an inconsistency between a substantive clause containing.
Clause will prevail upon.
And the annexures appended thereto.
Yes.
Which
Clause
would
will
prevail.
prevail upon, not the.
Which would prevail.
Yes.
So let us not join issues, Miller. Once your lordship has been pleased to hold it, we will be abiding by that.
Participate. That is what they are challenging.
Clause is otherwise.
Yes.
Your clause is otherwise. Homogeneous class, your lordship has been pleased to hold it as a homogeneous.
There is not be a
No, it's
within this class,
Right.
unless there is an intelligible difference.
No, no,
And Miller, we have.
let him be disposed. Right?
Mallots may take note, Miller, that we have allowed the proprietorship.
Yes. It's also admitting the.
Well,
Item not 12.
Might be zero. This is the inaction of operating laws.
Yeah.
Okay.
They actually rejected or it is a oral one?
Miller, they are saying they have orally told him, but
Yes,
there is
that
no
is what I'm
rejection.
asking. Have
There
you-
is, as of now, there is no rejection. As of now, there is no rejection.
They have not
It's a
taken.
premature one.
No, what happened, Your Lordship?
Sir, please,
They take a
they have
decision.
not rejected your bid. Then in that event, your grounds cannot be sustained. So it is a premature one.
But,
So let them first take a decision. If they reject, you come.
exactly.
If they do not reject,
But that's.
what is the difficulty?
Yes, yes, Miller. That
It's
I'm
a
saying.
premature,
Well, they are not doing and doing from all else. Miller.
whatever, they have not done it.
Yes, sir. That's what I'm saying.
The How can you proceed on a hoax letter and a person who disowned that I never did that?
After hand over the instructions, my lord, after inquiry, it was found out that the petitioner submitted forged documents, my lord. And he has been disqualified due to that reason. The signature of the
A person, now the difficulty, if you proceed and act on the basis of those hoax letter, never written to somebody, then what would happen?
that letter was received to our officer and accordingly inquiry was conducted by the concerned officer and the report.
Yes. Where is the order of debarment?
No, there is a cancellation, my lord.
Where is the, you actually talked about the debarment?
No, that is in the order itself, what you will see.
Where is the initial?
Yes,
What is the piece now?
page number is 182, my lord.
What?
182, my lord.
But that is not an order of debarment.
No.
They have simply recommended for initiation of a proceeding for debarment.
No, they have recommended for initiation of 1, 2, 3, my lord. Yes, no, what is submit, my lord, is the cancellation, my lord.
This is a
They
cancellation.
have cancelled, my lord. In
Now,
fact,
it's
the
not
what was,
essentially a question of fact. You have said that
my lord,
you have executed all the work, but hindrances were created by the authorities themselves by not issuing the drawing. They have not changed the site location. There is a lack of the engineering decisions
That's right.
to be taken up by
Right,
them.
right.
All these things. So essentially, it's the question of fact.
My lord, if it is, but this is what,
So that what will
my lord, this is what I had expected to fall from my lord, my lord. That is the reason I am prepared with the judgment of this honorable court, my lord. When there is a disputed question of fact with regard to my lord, certain thing, my lord,
correct?
and then there is a cancellation,
Correct.
and at the time of cancellation, no hearing is given. When there is a factual dispute, my lord, then that is illegal. My lord, that's a judgment reported in 1986, volume 1, OLR 631. Unfortunately, is
So this is a fact.
634. Well, last para. It is not disputed that the petitioners were called upon to show cause and show causes were filed. But where the petitioners entitled to personal hearing was the authority obligated to hold an inquiry. No hard and fast rule can be laid down. It would depend on the facts and circumstances of each case. But the touchstone is that the opportunity should be real and reasonable, and the owner of the person concerned should be dealt with in a manner just and fair. In particular case, after the show cause is filed, further inquiry may not be necessary. Namely, for example, where the allegations are admitted, where the owner of the person concerned has refuted the allegations that any unauthorized development or construction had been done by him as alleged, and where disputed question of facts are involved, upon resolution of which would turn the decision. It is imperative that such contentious issues, disputed questions are resolved by an inquiry into the question involved, at which the owner or the person concerned is given an opportunity to disprove the allegations or to establish his case. It is not enough that an opportunity to show cause is given and show cause is filed.
where fact and circumstances cry aloud for an inquiry for resolution of the disputed and contentious issues of fact. Absence of an inquiry at the original stage would not be just and fair. Even though the proviso does not specifically enjoin an inquiry, depending on the facts and circumstances, opportunity of hearing at an inquiry would be read into the provision. It should be kept in mind that an order under Section 91(1) has serious consequences for the owner of the property. But here I have been
Yes, they have raised an issue. You have not given an opportunity.
Page number 58, as per the terms of the tender, my lord, what was
So
written?
no show cause is required before you receive the contract.
Show cause is given, my lord, in this.
Show cause is given.
Yes, my
What
lord.
is, where is the show cause?
The show cause notice at Annex 10 at page.
So
Page
have you
170.
given a reply?
Yes, I have given the reply. Reply had not been considered in the well input order. That is what I said. At page 176, the show cause notice, my lord.
179 is the reply.
179 is the reply. And this reply has not been considered while issuing an exceptional at page 182. That is the only issue.
But as per the clause
Where is now?
page 58, if I may refer to the terms of the tender, my lord, it is 58, my lord. Rescission of a contract, when it can be done, my lord, how it can be done, my lord. To rescind the contract of which rescission notice in writing to the contractor under the hand of the executive engineer shall be a conclusive evidence. In light of this, my lord, show cause at page number annex 10 has been given, my lord, and petitioner submitted reply and considering the
What is the judgment that is this a technical rule, not a real one? If opportunity is given and the reply is filed and being accepted, then in that event, there is no question of any personal hearing to be given before we proceed to take a decision. Even then, there are.
Well, I agree with that proposition, man. Where not there is no disputed prisoner, what here right from day one.
If there's a disputed, could you are raising a dispute?
Well, my in fact, from the day.
Give me that, you are keeping it in the next week.
Yes, my lord.
The nature of the that's what the thing is rescinded. Now, so far as the department will consider.
No, department has not done.
Thing.
That is I want.
15th.
Your Millards, petitioner is a contractor. He has participated in a bid.
Now, twice he rejected at the technical bid stage. How can you award a contract to this in a subsequent?
Was
Was there any expedition by the
yes, the opposite party number.
He has today withdrawn. He's filed an application for withdrawal today.
What?
Yes, that bid petition is listed today, item number 51. Which
51?
yes, today's list.
No. With party number 5 has been awarded a contract.
Appointment part number 5 had challenged such non-awarding. Today, because of this order in the interregnum, he's now filed for a withdrawal. Two the technical committees.
Why you change your decision?
This after there was a combined evaluation which was done because of the grievances received by on the party. Combined evaluation was done in this matter, my lord. After combined evaluation, it came. There was the technical members. If I may refer to annexation 5, my lord, the report.
Oh, you are.
Yeah.
I'm on this.
Instructions.
There was an action 5.
Annexation
Instruction also. Very interesting. Page.
page 6, my lord.
If they can write so much of the facts, why don't they give an affidavit?
But I'll file an affidavit, my lord, because after the combined evaluation and taking into consideration.
It's 6.
Yes, my lord. The proceedings are at page 6, my lord.
More.
At page number 9, my lord.
Always participate.
page number 9, my lords.
Serial number?
Serial number 33, Grievance Redressal Committee. The matter went to the committee, my lords. Work has been given to opposite party number 5 and one work has been given to the petitioner.
No, 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 that is incorrect. I'll state now. It is incorrect.
One work has been given?
No.
That's what the instructions.
He is not eligible for anything other than CL number 8 of the
You
tender.
want both the works to be given to you?
No, my lords, I'm saying he's disqualified. As per their categorical stand, I'll show that.
Disqualification was that he is already having another work.
No, it is not.
At Bhadra.
Yes.
So that is what the authorities.
Now, my lords will see three conditions. I will show
Serial
three
number 8
documents.
notice which my petitioner is referring also. That also, my lords, in the second last paragraph of the instruction, that work he has withdrawn, my lords. That work he has withdrawn, my lords. Second last page of the instruction, second last paragraph, my lords, referring to serial number 8, Bhadrak work. That work, my lords, she so and so has bid capacity.
Yes, where going?
No, it's second last paragraph, second page, my lords.
Oh, it's very, very
The second last paragraph, I was really surprised.
Sorry,
that
preceding paragraph. That work has
He has
been,
no interest to execute the work at Bhadra.
yes, my lord. That work has been given to somebody else, my lord. Recommended.
So he's not having that.
No, my lord.
Now, my lords, my answer to that. My lords, may see, please come to page number 23. My lords, I'll just hardly 3 minutes. I have a case in 3 minutes, I'll establish. My lords, may come to page 23. 23, my lords, there are 18 words that have been floated. In page 23, along with together 18 words were floated. Serial number 8, 9.
Financial capacity. One of the, this says that if he's shown a financial capacity in multiple contracts, then at least there will be a substantial of that capacity because of those other works. And it appears that he has already appointed the other work. So that portion will not go.
Now,
Be very reasonable.
that is in that my lords, I'll explain. That is not correct. I'll explain, my lords, may see, just my lords, may see.
As a more pragmatic approach.
Yes, yes, my lords. My lords, 46 may be seen.
Yes.
See page 46 for a moment.
We're not going to.
Yes, technically, I have two things, two documents. If I do not, I'm not able to, please, my lord, may get continue hearing. Just space and clause 7 message. It says that the time of bidding.
Instruction reveals
No, it is not correct. My lord, it is not correct.
Instruction reveals.
Or he is disqualified or
Sorry.
disqualified. Not so.
16.
Yes. If you had one. They have re-tendered.
Retender, and I have participated in the retender.
First
one is
re-tender.
first one is cancelled.
Anyhow, then re-tender. Then what?
I have I have also participated in the retender. They have rejected on the orally. They have told at the time of technical evaluation. They have orally.
There is no document.
No matter. There is offline tender. They have not supplied any document.
Have you rejected or not?
Yes.
It's from a handover to instruction.
Please tell me openly.
A copy of the instruction be given to me.
Because the EMD was not submitted in the prescribed format as per the contract members.
But the amount was given.
Yes, sir. I have given a fixed deposit. They have told it should be on DD format. As per OGFR rule, it should be on fixed deposit as well as the
deposit, and they want the
DD format. Your lordship may see what they did.
fixed deposit.
Your lordship may see in the first tender, my lord, in the first tender it was fixed deposit. In the next retender, it has been done DD because I have participated in the earlier tender. That fixed deposit I have submitted in the second tender also.
So when you know that they have changed the criteria.
No, ma'am, that is
why the fixed deposit you could have.
As per the
DD.
As per the OGFR rule, your lordship has already gone through each banner. It is the DD as well as the fixed deposit is entitled to be the EMD and toward the security also.
Yes. How can you too technical?
Page number 25, it specifically mentions.
No, I understand. If this clause runs counter to UGFR rules, then
The ground is not taken in the reproduction order.
Yes.
where is the ground? When she says confusion should not be.
I have stated it is against the OGFR and OPWD code.
Please,
In paragraph 8.
Yes,
One line.
Highlighted provision as stipulated under the OGFR and OPWD code, my lord.
Yes, they have said so.
Because it's as per what clause, because this is governed, every tender is governed by its own terms and conditions.
If there is a rule, then you go beyond the rule. I'm asking. That's the freedom which is given. Either there should not be any rule. Then whatever the authority will put a terms and conditions in the tender, no difficult. But if the rule governs that what the tender should contain, can you put a condition which runs closer to the rule? Where is that OGFR? Which clause?
212.
212 of the OGFR.
Bid security. Mention. OGFR 2023. Roman 2, ma'am.
Yes. Basis of this. It received the concurrence of the governor?
Madam,
Has it received the concurrence of the governor?
it is in the,
Or it is not there?
it is not there, ma'am.
Because I have read the preface.
Yes, ma'am. That is not there.
I have read the preface. It is merely an executive instruction.
It is the government financial rules, my lord.
No, sir. The preface you have also read.
Yes, yes, ma'am.
It is merely an executive instruction. That's why I am speaking of it.
Ma'am.
Now, if it is an executive instruction, then it is not a legally enforceable document. At the behest of a third party.
Ma'am, it is the Odisha general financial rule which has
Sir,
been.
what rules have been given? I do not dispute with this,
The
but
company
it
has
is an executive instruction. What is the
Yes,
source of power to make a rule? The rule making power must emanate from a
Yes.
constitutional authority, from the constitutional provision or from the parent statute. What is the source?
in the introduction, it has been stated, my lord.
Where? What is that? I have seen the preface.
These rules may be called Odisha General Finance Rules 2023. These rules shall be applicable to all departments, sets of department, field office attached to subordinate officer.
What is the source of powers to frame a rule?
Sir, it is not written in the side
No.
also.
Then it has to be under preface.
Instruction. Don't be too hyper-technical. We understand the technicalities of law, but equally important is the social and the substantial justice.
It's here.
How can you be too technical on that? What is the difference between a fixed deposit and the demand draft? Nothing.
My instruction
Both are issued by the bank.
My instruction says.
Both are issued by the bank.
Pledge, my lords. I would say instruction says it's in the form of a pledge, my lords.
Is a negotiable instrument.
Yes, my lords, but however, my lords, this tender is for emergent purposes, my lords.
No, continue. The gentleman has given. How can you? That shows the discrimination. That shows the favoritism. That shows the nepotism. You do not want him to come. You want somebody cherry picking, a blue-white person to come.
There were 3 participants in this bid, my lords.
Correct. He merged the lawyers because all the 3 quoted the same price.
But technically disqualified, I don't know about the financial.
No, financial bid, he says he was declared and was.
No, my lords. He was technically disqualified.
Technical disqualified.
Oh,
Technically,
Yes,
Yes,
ma'am.
no, it's technically disqualified, my lords.
Financial.
it was not.
how the financial aspect is given, what is the rate which they have opened?
They have opened it 138, my lord. I have given
And what you quoted?
I have quoted 49 per quintal, 49 per quintal, my lord.
And he has quoted,
138, my lord.
just imagine the difference.
I
For
quoted
more than 90.
I have
Yes.
I am filing the memo to that effect because
Yes, the-
I have no idea, my lords, the amount.
No, sir. $138 and 49. Practically 90 difference.
and also he is the single bidder, my lord.
My lords, only thing.
It should be referred to the higher authority. But without referring it, they are continuing to select it.
If they request funds.
Technical.
Okay.
This aspect in within 1 week, my lords, because they have to start procurement from, because it ends on 31st August, my lords. And the supply, whatever is remaining, it's finishing, my lords. They have to start the new tender, my lords.
I don't believe in that representation theory. If there is a glaring illegality on the face of it, delegating a party to in the hands of a person, don't believe. You don't believe.
What I got instruction is that they received this yesterday, my lords.
Sorry, you can't. And this is the disparity which comes.
He was very well aware of the terms.
They will then say
Participate.
the OGFR, it is you who have framed the rules. We'll not go into the nuances of this. And you are debarred from arguing.
The terms does not.
Will you not follow the rules? I'm asking this. Forget about them. Will you not follow these rules? If it says that it can be done in this form, how can you restrict it? Two 12 Roman 2.
They are saying it's, but my.
212 Roman 2.
Well, I have gone through that.
Have you seen the DD and the fixed deposit? Both are there.
The instruction says it's in the form of a pledge. That's it, my lord.
That's true. There's there.
Pledge is not included here, my lord.
It's not a pledge. It's a fixed deposit.
No, my instruction says that they have submitted in the form of a pledge, my lord.
And very interesting, what is the span or the tenure of the contract?
Yearly.
Tell me,
Till March.
1 year. please.
1 year.
1 year.
whether the DD will be remain valid for 1 year? Tell me. It has a shelf life of 3 months or maximum 6 months. What is the purpose of taking a DD? Whereas the fixed deposit has the shelf life, it may be a fixed deposit for 2 years, 3 years.
That
Which is more, which is securing more?
fixed deposit.
So,
The thing is, my only point is that
no,
it was
no, but
as per the terms of the
I will say this runs counter to that. And it ordains that every department of the government will follow this.
But are you following any other?
No, they
You
can't.
you are following this rule only.
because the term does not mention any, because it is under a
That's
scheme.
true, but
It says 1 Roman 2 says these rules will be applicable to all departments, heads of the department, the field officers, attached and subordinate officers.
This comes
Are
under,
you beyond the day of some department?
this comes under a program, my lords. PM. This tender has been invited under a program, my lords.
By whom?
By the collector, my lords.
So is it, it's not a part of the government or it's official? What department he holds? The,
Collector, designated.
the, and he talks about all departments. Is it beyond the department of the government? No. Oh. Who is the, have you completed the successful case? Notice the people.
Okay, number
4.
4.
Issue notice on the OP number 4. right now, put in the requisites within, or better, you, sir. The petitioner is directed to serve the copy of the writ petition Which advanced.
Small amount, no, sister. Let's make keep it to next in the meantime, the instruction there.
We are sending it for the future.
Kindly see the instructions.
No,
Doubts have been raised with
No,
respect to the
nothing.
bills
you
submitted.
have, you're the chief district medical and public health officer
Yes.
has recommended and admitted the liability.
But those bills were recommended to the collector for its approval. But the collector, you will also may kindly see, the collector has raised doubt with respect to extravagant and doubtful bills. Now,
What?
he has directed,
What?
but the bills are extravagant and doubtful. That is the word.
Extravagant. What is the word?
But that is the word used. Well,
Extravagant from where you got it?
that is the word used with the instructions. So that
What
is
the
why I am
meaning
saying
of the word extravagant? And that is in relation to a bill.
extravagant and doubtful. And a audit has been directed, and with the approval of
Has
the
he not
state government,
supplied the material?
that's-
What is the doubtfulness?
but he has submitted the bill with the endorsement of the district headquarter hospital
No.
as well as the CDMO. Those bills have been placed before the collector for approval. Collector has raised some doubt and directed for an audit. With the approval of the government in the Department of Health and Family Welfare, now an inquiry has been undertaken. Your Lordship may kindly see the next document that is appended to this.
Collector is not managed.
That is
No,
government.
the only doubtfulness that would come that he has not supplied the goods yet he has the bill. So what is the?
But bills.
Responsible authorities who have received the goods, they have certified, and he is sitting in a distant place in a most, I would say, comfortable environment. Is raising a doubt.
And bills and bill numbers have everything has been submitted, and basing on that, an inquiry has been directed by the state government. That document also has.
How long will it take? Because it will not take more than a week. And you have directed on 29/4. Now we are in August. Nearly more than 3 months has elapsed.
At least 3 weeks in between.
The instant petition is
is of additional personal security, and after completion of work, Lordship, it has to be.
Mr. Joshi, Army Council.
Lordship, Joshi is not well today, Lordship is suffering from viral fever.
So let him come, recover and come.
Lordship,
Who is not depriving? He is not appearing there today.
He telephoned me just to apprise your Lordship only.
Release.
But
Work is not complete.
now he's raising a dispute.
Let's
Let me come next week.
let's see page 3 and page 4 here. It was communicated to the contractor, and at page 5 towards the bottom, he received the same.
A copy may be served to me. The copy.
No, he will give. On the last topic.
It go.
Yes. Yes. You call them.
Item number 20.
No, no writer. No writer.
These are nothing.
Kind of a rate, this kind of a what, are we going to sit as a engineer?
In fact, in the
As an engineer, we can't do it.
Lordship,
Look at the prayer, brother.
Yes, sir. Can I
What,
see the
what prayer? We are not an engineer, we are not an expert.
No, not. Can you see the memo?
Huh?
In the
What memo?
Lordship, in the meantime, Lordship, they come up with Lordship.
Then you make an application for amendment. We can't,
In the meantime, Lordship, the matter, Lordship, can you see kindly, with 3 lines, Lordship, this, with 3 lines distance. In the meantime, Lordship, my grievance, Lordship, already litigated. They have taken.
withdraw it.
They have taken a decision, Lordship.
Then
Only that adoration, Lordship, can be disposed of.
what is this?
Well, that is the municipal.
Municipality, Lordship. My entire allegation against municipality, Lordship, not against state. They have taken a unilateral decision and contract with their own arrangement. I am the successful bidder. Now they have come to the practice.
He has been awarded about.
Yes.
It is submitted by Mr.
21.
Also,
21.
can we say order dated 5 number from
What is the reason?
He has not done the similar type of major works. And plant and
Why
machinery.
you have not communicated the reason?
last term, 50%.
It is not your responsibility to communicate the reason.
Well, he has to log on to the website or he has to ask for the reasons why he has been rejected. He has not done so. And if it once I can communicate it, no problem.
Supply.
Supply. Now the work has already been awarded and the agreement has been.
You do not want these entitled to a reason.
No, the reasons have been given, but in the meantime.
That's the point.
Only to accommodate opposite partner.
No,
They're
that's
not.
If the rejection is found to be correct, sustainable, then the question of what is the contract, that is the different issue.
Right.
You should know the reason.
Right.
On the last occasion, the matter was adjourned.
Complete ownership blacklisting without any notice.
One. Touch. There is format or something. Your contention in the red petition is that you were awarded a contract to supply a definite quantity as mentioned in the tender.
Let's see.
Now they while issuing the letter of intent, they have increased the quantity.
Lordship.
You ask for extension of time.
Great.
They have rejected it.
No, subsequently they blacklist on that score, Lordship, they
Where
blacklist.
is that?
Lordship, annexation 11, Lordship, page 94.
11, I do not find. Page
Lordship, already amended, Lordship, page, Lordship, 94 now. 4. Already amended, Lordship. Last occasion it is amended.
where is the amended copy? Oh.
Page
And you also amended the prayer.
Lordship.
Huh?
Lordship.
Milord, we have received the amended copy, Milord, and we are filing counter affidavit in this case.
How can you? The only point is that you have divided. Have you issued any show cause notice?
No, Milord. Yeah, no.
Can you?
No.
Can you?
On that point, Milord, we have not.
No, it has to go.
And so far, other prayers are
AKG,
Yes.
Panda infrastructure,
Lordship.
any judgment which have come,
After that, we have Lordship judgment. Lordship.
erroneous judgment.
Lordship.
Milord, so far the other prayers are concerned. Milord.
But we are not concerned, we are simply debarring him. The department has to go, they have to initiate the proceeding. Well, I have already said that.
Right.
That's the principle.
Lordship.
In Arthur, we are articles.
After that, we have Lordship.
Yes, that's it. Restricted to department.
Yes.
Yes.
23.
Your Lordship's order dated 5/8/2026.
The same issue, my lord, 0.99 up to 2 decimals. Will draw Lord's attention on 17.2. I think when the state itself has created a ghost, my lord. There should have been more clarity in these type of, my lord, directions.
We will change this matter today only for orders. That is the last order passed. Because this matter, your Lordship have already heard. I filed the counter affidavit. 5/8/20.
We have also.
My lord, I'll take, my lord, 1 minute by the watch, my lord. Just 1 minute.
What?
But please see 17.2. The more I read, my lord, as a student of law, my lord, I get more confused.
You have
17.2.
7 of the petition, yes.
It's page 75, my lord, would see page 75, clause 17.2. I don't feel, my lord, any need of these type of clauses, but yet it has,
Now
since
they
we,
have amended it.
my lord, if they admit, my lord, then they're creating, my lord,
No.
they're admitting, my
Now
lord,
they have
after.
amended it. Now there is 15% jury.
Yes, my lord.
There's gone.
So, now, my lord, would see 17.2 just for a moment, my lord. If the rate quoted by bidder is less than 15%, pay 75, my lord.
Yes.
If the rate bidder is less than 15% amount put together, that such bid shall be rejected and the tender shall be finalized basing on merits of the rest bid. No dispute, my lord. It is now it has a proviso. But if more than one bid is quoted, decimal up to 2 numbers will be taken for all purposes, either at the estimated cost put to the tender or less than the estimated cost put to the tender. Now question comes, my lord, if any party is not giving the figure of not giving a round figure and is quoting a rate which has, my lord, the impact of more decimal points than 2, then it will be considered only up to 2. So my friend's price is 5 times 9. So why not it be restricted to only 2 stages? It is not only for 9, my lord. It can be for any decimal. Even it can be 2, 2, 3, 3, 4, 4, anything. So if their amount is converted into figure, converted into decimal point, percentage, it is not that one should be ignored, because then it will not be harmonious construction of the contract. This is not has given without any purpose. This has some purpose. So if the purpose is that while quoting the rate, is it their case that they can ignore point number 2? My submission is that not point number 2 cannot be ignored. Point number 2 rather is a charging section. They are directing that while quoting the price bid, what is the manner, in which manner you would quote the price bid. So they say that you quote the price bid, but while quoting the price bid, if it is coming into decimals, then it will be restricted to 2 decimals only.
I understand that if the quoting the price, if it involves more than 2 decimals,
my lord,
say 5 numerical numbers after the decimal,
my lord,
then it should be restricted to only 2 decimals.
Only 2. So now my lord would see, my lord, their page 7, para 5.
Para 13 and 14, you feel
just a minute, sir.
Picture has been given.
Just give me 1 minute, sir.
Para 13 and 15 of the compressor.
Just a minute, sir. There is no chorus argument system, sir. I'm already on legs.
Sure.
Para 5, my lord. Page 7. Para 5, page 7 in the paper book, my lord.
Yes.
So, my lord, the person who is L1, his bid is 14.9999998. Because they do not want to touch the figure.
I understand you wanted to say that you can't take it beyond
double line
numbers after decimal. So if that is taken, then all the 4,
yes, my lord,
they come on the same footing.
Yes, my lord. Then, my lord, page 76, because they have to take the responsive bid into account. Now, if the figure is more than 99999, whether that bid would be considered as a responsive bid. Page 76, clause 2, 20.
Yes.
Award of contract. The authority, after evaluation of price bid, shall recommend to the competent bid accepting authority for acceptance of the bid to the bidders who is found qualified as per the bid condition and whose price bid is evaluated as the lowest responsive bid. Responsive means 17.2. Your bid should be the lowest, and while quoting the figure, it should not be anything beyond 2 decimals should be ignored.
Now, if there is a tie in the percentage basis, then what?
Then, my lord, rebidding among the successful lowest ones. And that was correctly, my lord. Majority of the parties have, while submitting the bid, majority have quoted only 14.99. The gentleman alone has quoted 14.5 times 9, because he read first line, did not read the second line. Second line of 17 point.
There has to be a difference of nearly 6 or 5 lakhs and all.
Well, in fact, the amount is 518 crore. So 0.1 means 5,18,000. So there could be, if I'm quoting I am quoting 14.99 and my friend is quoting 14.98, then if there would be gap of 5 lakh. So there can be 3 lakh, 4 lakh gap, still I will be 14.99. Because 518 crore is the figure. So 0.1 will represent 5,18,000. So therefore, my lord, the amount may not be so much relevance. My lord, the quoting of the price will certainly should be in consonance with the percentage point.
I understand. You wanted to say that 20 has to be read conjointly with the 17.2.
My lord.
This is what you were really wanting.
I go down, my lord. Yes, this is my humble submission. Okay. And this is restricting to 2, only 2 decimal points. So if their decimal point is crossing the limit of more than 99, my lord, more than 2 decimal points, then rest should be ignored.
That's all. Yes, now you respond.
My learned friend wants to import certain language, that 14.99, which is absolutely not ingrained, not discussed, and not even it doesn't contain in the DTCN. Only 15% so far as that
17.22 clause 17.22 is never.
It never talked about 14.99. It says less than that anyway.
Less than 15.
And now if somebody, my lord, just to juxtapose what my learned friend said, let us say I quoted a figure of, my lord, 10% less. Under this clause, if I read it completely with your lordships, if your lordships would read it, it doesn't disqualify me also, even if I am not the lowest bidder. For the lottery system, I have to be included. So is it, Lord, it has to be harmoniously constructed so that it gives a meaning. If your lordships would read,
please come to what I
17.2, yes, may read this.
that it says that if we look to the tender is, then everybody has quoted the same, then it has.
No, it doesn't speak about same.
No, it is talking about.
No, if your lordships would read that.
That refers to the price bid.
Price
refers to the price bid, not the percentage bid. I'm sorry.
Read slowly, sir.
Yes.
If the rate quoted by the bidder is less than 15% of the amount put to tender, then such a bid shall be rejected. So this is one ground on which the rejection. Straight away. Irrespective what he quoted, if it is less than 15%, go. Then, and the tender shall be finalized based on the merits of the rest bid. What is merit of the rest bid? But if more than one bid is quoted, then decimal up to 2 numbers will be taken for all practical purposes. Means after the decimal, 2 numerical numbers will be taken into account, either at the estimated cost was put to the tender or less than the estimated cost put to tender. The tender accepting authority will finalize the tender through a transparent lottery system. So it is really coming under the percentage basis. Otherwise, decimal will not come. Or where all the bidders, representative, concerned, executive engineer, division will be made present. Now there are 2 possible interpretations. One is that decimal is attributable to the percentage which is to be arrived, or a decimal in respect of a paisa to have been quoted, to have been arrived. There are 2 possible views which can be taken. Now, what 20 says? 20 says that the authority after evaluation at page 76, the authority after evaluation of price bid shall recommend to the sufficient bid accepting authority for acceptance of a bid to the bidder who is found qualified as per the bid condition and whose price, now this word sentence is important, whose price bid is evaluated as the lowest responsive bidder. Now there are 2 things. One is lottery system under section 72. Another is the last sentence. What is the meaning of this word? Whose price bid is evaluated as the lowest responsive bidder. What the council is saying is that if 1% or a minus 0.01% will make a difference of 5 lakhs, 4 lakhs, because it is a use, the estimated cost is use. Now, even a fraction of 3-4 lakhs does not really changes or bring a very radical changes or a significant changes. It would remain 14.99 to that extent. But going beyond 2 numerical numbers after decimal, he says that it is not permissible. Now we have to harmonize these 2 provisions. What does it mean?
May I take your lordships to clause 5.10 at page 49 of it.
Yes.
The bidder 5.10 submission of tender.
Yes.
The bidders would be required to register on e-procurement marketplace so and submit their bid online. The department will not accept any bids submitted in the paper form. The bidders should quote their tender contract price at the prescribed field place provided in the e-market.
Sir, that is what I'm saying when you talk about the clause
Price.
20 also is, that is the last sentence, and the word
Yes.
Whose price bid? Because it talks about a price bid.
Price bid.
That is what I'm saying, that we'll have to harmonize between 20 and 17.2.
Yes.
Now, if there is some kind of an inconsistency which is noticed by the court in a different clauses of a contract, then which should prevail, the earlier clause or the latter clause?
The earlier clause will have to prevail, my lords, because the subsequent one has to correspond to it.
My submission would be,
If
both
we
prevail-
can harmonize, there is a first attempt by the court to harmonize both the clauses to operate simultaneously in the respective fields. In the event the court finds that they cannot be harmonized, they run counter to each other. Then in that event, the second principle would be that which clause will prevail over the other.
Unless the clause is clarificatory.
That is what I'm asking. Which should prevail?
My lord, in my humble submission, there is no contradiction here, my lord. It is only, my lord, 17.2 is only a guiding factor that how I should quote my price bid. So I have right to quote anything.
Is a first option.
My lord. Yes, my lord. I go down, my lord. Yes.
That is what I'm saying. This is what a first option. Now I am on the second option. Let us see. We have not framed our mind as yet. Let us see that if it runs counter, then what should be the norm? Which would prevail? Earlier clause or the latter clause? Or a third one is that if any of the clause is mere clarificatory in nature.
Well, my humble submission is 17.2 should prevail because this is the only qualification which is giving a how we should quote a rate. So quoting of rate is guided by only 17.2.
Well, then clause 20 cannot override 17 also.
20 is not overriding 17.2. So 20 says that which bid is overriding, which bid is responsive.
And then 17 also 5.10, only the price has to be taken, price bid.
But 17.2 does not.
What a price bid.
Yes.
But 17.2 does not say that price bid should not be taken.
Yes.
We leave it upon your lordship, my lord. But in fact, my humble submission that even 17.2 does not say that price bid should be ignored. It says that you quote your price because we have to quote the price. It is an EPC contract.
Yes.
But while quoting the price, say, my lord, my figure goes haywire. My figure goes haywire, my lord. And it has 5 times 9 or 5 times 4. Then, my humble submission that rest of the 4 should be ignored.
The thing is that what he wanted to say that it is a EPC contract.
Yes.
The estimated price.
Price. It is not on percentage.
Is a contract. But what is it is of selecting the successful bidder that is provided in 17.2.
Well, 17.2.
It talks about the percentage basis.
No, my lord.
That is
Percentage.
That wanted to say.
That is what I am clarifying, my lord.
Yes.
So far as 17.2, that 15% is given, my lord, 15% to find out the threshold. What would be the threshold? Now the bid price, how they quote the bid price, if your lordship may kindly see page 241.
Visualize the situation. Yes. There should be a clarity in the clause also. When you say that it is at the threshold, means whatever the price you quote, if it goes below 15%, then it will be rejected. So what you have to do? You have to bring that price quoted by the intending bidder into a percentage basis vis-a-vis the estimated cost. If you find that it is less than 15%, say for example, a price is quoted which is less than 15%. What you will do?
But price here they have quoted the price in figures, not in percentage.
Mr. Das, I understood. Please try to understand what is playing in my mind. How you can work 17.2.
But that
how you will work?
That I have explained.
What is the workout?
But that that we have explained in para 13. And
What you have explained,
but your lordship, that is why I bring your lordship
Please.
and
read it.
counter affidavit. In fact, your lordship have already seen that. Till then, I
No,
that is
13?
page 11, para 13.
11 of the contract.
Yes.
Para 13. That after opening of the financial bids, it was found that the amount put to tender was 518 crores 460,533. Consequently, 15% below the estimated amount worked out to 440 crores 300 so and so, which constituted the rejection threshold under clause 17.2 of the bid document. It is in this context, it is respectfully submitted that the successful bidder, PS became, for whom my grand senior is appearing, quoted this amount, that is 440 crores 33 lakhs 91,470,
Which is?
1 paisa above the rejection threshold prescribed under clause 17.2. Therefore, the bid was admittedly not less than 15% below the estimated cost and consequently did not attract disqualification. Then your lordship may kindly come to para 14. Para 14. Para 14, I'll just straight away I'll take your lordship to the relevant portion instead of reading the entire thing. Para 14, just 10 lines from the bottom. It is further submitted, if my lords have got it. It is further submitted that 3 other bidders, namely PNC Infratech Limited, Dinesh Chandra R. Agarwal, Infracon Private Limited, and Sri Balaji Engicons, for whom the petitioner is appearing. Balaji Engicons Limited, Patel Engineering Limited, joint venture, quoted 440 11 paisa, which is admittedly higher than the amount quoted by PES became to the tune of rupees 5 lakhs. This is the difference. Accordingly, PES became emerged as the lowest responsive bidder. Now,
that is what I'm
now this 2 decimal, what my learned friend is always hinting at, my lord, that 2 decimal is only confined to the percentage. 2 decimal can also be counted. My submission would be that if your lordship will find at para 30.
Very interesting. Let us understand the. You have calculated the price on a bid price basis. Please consider this. There are 2 aspects of the fact. 17.2 does not really talk about the price bid in that sense. He says that the price bid has to be converted into a percentage basis vis-a-vis the estimated cost of the tender. And then if it goes less than 15%, then in that event, it will invite a straightaway rejection. No doubt. Then what is the first exercise of the tendering authority? That whatever the price is quoted, you have to first ascertain whether it is less than 50 or it is more than 50. Suppose any price is quoted, if it goes more than 50, it will be taken as the valid one. If in that where the percentage is quoted, in that the decimal is referred, does it mean the decimal on the base or in relation to a amount quoted or a decimal in respect of a percentage? Right.
Amount. My lord, it has to be understood as amount quoted because
now the question is that suppose the amount is quoted. Now it appears that if 2 decimal has to be, then there is every possibility that if you work out a percentage, then there will be a same percentage that will come because of the estimated value of the tender, the the difference of 3-4 lakhs or 5 lakhs does not really affect the two numerical numbers after the decimal. It would remain intact to that extreme. In that perspective, how a lottery procedure was incorporated in 17. Why? Why you have introduced the lottery? For what? If the price varies, there is no question of any lottery to be conducted. But if the percentage remains same, when the price may not be same, then in that event, what? Then 20 comes, because 17 value, what you say is that one bid is quoted decimal up to such and such, either at the estimated cost or a less than estimated. Tender accepting authority will finalize the tender through a transparent lottery system. Why it is introduced? It has to be on that. But 20 says that the authority, the competent bidding accepting authority, while accepting the bid, out of the person qualified the bid conditions, whose price bid is evaluated as the lowest responsive bidder. So, if this talks about the price as the lowest responsive bidder, then it is a price which has to be taken into account. Now, there is another confusion. This whose price bid, the word is whose price bid is evaluated as lowest responsive. Evaluation, does it not mean evaluation in terms of clause 17.2?
My lord, even if we go by only the price quoted by the bidder,
Straightforward.
my lord, kindly see the difference. My lord, even if it is the price, what is the difference, your lordship?
The difference is used. 3-4 lakhs, 5 lakhs.
No, but 5 lakhs so far as decimal point is concerned. But if your lordship may kindly,
they have also quoted the price. The price appears to be nearly 5 lakhs difference.
no, but your lordship just kindly have a glance to that figure.
Okay.
But my lord, so far as the successful bidder, my lord, so far as the
Come to page 7.
7.
No, they have quoted 440, 33, 91. And they have quoted 440, 39. They have quoted 440, 39, 440, 39. So there is a difference of more than 5 lakhs. Who are those PS engineers?
but the PS engineers, they have quoted 440, 33 lakhs, 91,000.
Let us go by 33 lakhs, sir. Don't go by others.
Yes.
33, they have quoted the same
39.
39 and 39.
Yes.
Who says not, sir? This is also their cases. Now, the difference is,
Can I try to make a response to your lordship's query?
your standing is something different. That is what I'm saying.
Lord, can I respond subject to your lordship's
Yes.
Now, let us think of a situation, 15 years straight away equal or less than 15 years out, disqualified. Now, below that, if somebody is there, forget about 2 decimals, 3 decimals, 4 decimals. Now, does beyond 2 decimals get disqualified? Is no.
No.
So he becomes a responsive bid. So then the comparison is 20 amongst them who is the lowest.
That is what is, I say that the second probable interpretation.
So once I'm not disqualified, then my bid becomes responsive.
The question is then why the lottery system?
If there is an equal, that is the lowest has been given.
May I clarify? I'll just clarify.
You will get it. Give it.
If a lordships read 17.2 with 20, why it says lowest amongst the responsive bidders, those who qualify, who are not automatically disqualified, everyone becomes responsive. Amongst that, the lowest, if it is equal amongst it. Now let us hear in this case, the other three are equal. Had I been disqualified, then whose would have been? Then the lottery system comes. So once I'm responsive, or I do not, or I don't get disqualified, my bid cannot be straight away written off saying that no, it is beyond 2 decimals, so I have to be part of the lottery system.
My lord, I clarify. My lord, I will clarify. There is, confusion, my lord. 17.2, my lord, if the parties are not entangled in 17.2, then my lord 20 would apply. But if parties bid are falling in 17.2, then they cannot say that sorry, I am also falling in 17.2, but please apply 20. 17.2 is dealing with an eventuality that unfortunately, if you are while quoting the bid, if your bid are more than 2 points of the decimal, then please reduce to the 2-point decimal. Ignore the rest of the decimal. So 20 says that if your case is not falling in 17.2, then apply 20. It cannot be said that 17 is just for without any purpose.
Let us ponder upon the thing.
My lord.
There are another matter when it is fixed.
Please, my lord, but whenever, my lord, I think, my lord should.
This matter is, your matter is fixed, right?
Lord, next week,
19th.
Next week, my lord.
Keep it on 19th and set it.
Deeply obliged. Deeply obliged.
So far as this present tender is concerned, here the work order has been issued.
Oh, he appears.
One of the cabinet, he has already started work.
He's now formidable opponent, right?
No, my lord, we are on the issue of the legality of it, but not the factual aspect.
For this matter of 19 for orders.
Deeply obliged. Grateful to your lordship.
Item number 24.
24th, my lord, on behalf of Mr. Surangi, I have filed the memo for withdrawal.
Yes.
Yes, please.
No entry order. Yes.
No, my lord, there is no entry moment.
Item 25.
So, if I may please your lordship, on dated 30/7/2026. Very clear. On 22/7/2026, it was directed the learner state council to obtain instruction in the matter.
Lord, I've obtained instructions, I've given my lord, but if my lord should permit, my lord, I'll file my affidavit in this case.
Copy we can't be sir.
I'll file an affidavit.
No. Taking a technical plea on the last of this.
On the last,
Yeah,
occasion,
that
yes,
was-
that has been
So
done.
now-
Yes, that has been done.
What is the?
Now, my lords, I have obtained instruction on this. My lord, my dispute is, I issue work order, but in agreement, when my
issued work order.
in my favor, my lord.
The work order was issued.
In my favor,
I issued a work order.
I am issued in my favor. Then when I going to start the work, they obstructed. And I also give the telephone number, photograph of the police complaint that they want 10% of the total contract amount. And then I made a complaint before the authority, page 53, the inquiry was going on. I participated in inquiry, but on the very same day, before conclude the inquiry, they terminate my agreement and 20% penalty imposed on me. My lord, I have given the instruction. My lords, if my lords will see
the extraction.
My lords, the date of commencement of the work was 18th of December 2025. 18th of December 2025, date of commencement.
Extraction.
No, that is not the case. Inquiry has been conducted. I am coming to that, my lord. The date of commencement of the work was 18/12/2025. Date of completion was 17/2/2026, 17th February. Now, my lord, the petitioner for the first time visited the site, my lord, where the work was to be done on, my lord, 9th of February, just 1 week before the period was to expire. On 9th, he came with his men and machinery. On 10th, he again went away, saying that I'm being harassed by some people, I'm being obstructed. An inquiry was duly cast. Yes, my lord. Yes.
2 weeks, 1 week, 4 weeks.
Yes. Item 26.
Serving copy to me, madam.
I've given you opportunity for interviewer, sir.
My lord,
One.
my
1 week for you.
obliged.
But it's under challenge.
One. No. Nothing permanent planning.
I have two judgments also of Supreme Court.
Under infrastructure.
Under is there, another one is also. Which you refer
Jurisdiction
to?
is there,
Yes.
process is there.
And I have no preview of contract also with the government. The contract was with MCL. So there are two blacklisting orders.
Mr. No, something unheard of. It has already been highlighted in many of the judgments of the Supreme Court, saying that the debarment debarment tantamount to a civil debt. Article 295 is also where the contract can be entered into.
I find from the record that a show cause notice was issued to the petitioner.
Well, they have said it has not been issued.
Will I kindly see Annexure 10, their document, Commando Industrial
Page?
Page 226.
266.
266. Sorry, 266, Annexure 10. In reference to the so-called letter issued to you, wide our letter that took so and so regarding exhaustion to
That is, we have issued it to somebody else.
their employees.
This is the Commando Industrial Security Force. They are.
They have issued
They are
to their
they
employees.
have issued it to
But so far as-
Pragyanmita Burgi that
But before
must have taken an action against this subcontractor or whatever.
We were supposed to supply manpower, so.
Understood? It's a subcontract.
With them, then.
Subcontract. So
Then
it
we have
is
no preview of it.
vis-a-vis, you have no privity of contract. Not even a privity of state. So
I understand the collector letter doesn't say so.
No.
But the collector's order
So.
Whether even if
Yeah,
any
that must be
so-called.
That is the between him and his other, his subcontractor.
Also may keep it to next week.
What next?
This annexure 25, I'll just take instruction whether
What
they have.
annexure? This is his document, sir. 25 is where?
Annexure 25 is the
Page-
interim order. That is at page 320.
320.
Mal.
That's 15.
50 is collector and district magistrate. Annexure 25
is correct.
320.
I get exactly.
You're talking about, sir, there is no question of any so-called. There is not even a reflection.
But that
A
appears
revenue
to be itself, my lord, I pray just one time so that
No, sir, don't gain time. Unnecessary. If you want, you can initiate a proceeding, go for a show cause, whatever you want to do, give them an opportunity, but this order will not stand. And where is the second one?
Lordship, just thereafter, MCL also has given us same thing, Your Lordship. And MCL in fact has done it on the behest of the government. No show cause, nothing. 321.
So at best you have a cause in MCL.
No, both.
Both no show
Now
cause.
here they have a.
No, both no show cause. Both of them have debarment. And the
They
only
have-
thing MCL has limited it for few years.
The imbue is more damaging. Permanently banned and blacklisted, that is more damaging. Series LCL has shown some sympathy for 1 year. Your organization is in for 1 year. The last one, now the other one, in view of the breach, is here, but permanently.
here both the Union of India and the MCL are parties to the writ petition. If they have taken up liquid so that they can also give their, they can appear and give their. But so far as judgment,
It's a open
but
and
so far as the
shut
judgment is concerned, I will
All
not.
the judgments are.
I will not.
All the judgments are against.
And I will not.
Yes, PSG will be representing MCL.
Manly Coldfield, there is a separate penal.
No, you appear. No separate country. What kind of a thing is this? Without issuance of the show cause, nothing, and you have blacklisted him.
Sir. Protection is reputed by MCL only.
Yes, we had a preview contract with MCL.
MCL. But it's there to government.
Because the MCL has communicated to him.
It seems that there was some newspaper article. And then the government said, we have come across this newspaper, they write.
Very interesting. The government, the collector, in his order says that the inquiry is underway and blacklisted permanently. My goodness. It does not fructify, underway and then blacklisted permanently. No, sir. Both.
They were
We are directing you to-
manpower for the medical college, man. So that is why.
I understand, sir. The law cannot be changed.
The order, I cannot defend this order.
It's not.
To be honest.
No.
But so far as, if I grant us 1 week time.
We are directing you to appear for MCL. The copy has been served on MCL.
MCL, your lordship's notice had to go. They don't have a, but union.
Sir, why here? I do not know.
Yes,
The
yeah, that's
writ petition is not served
unlike
prior to a filing.
yes, we only serve it to state and only to
I do not know why.
I know. So, your lordship, what
I think
happens
in every high court, there is a rule which says that no writ petition would be permitted to be filed unless the copy thereof is served on the parties.
Ministry law also some issues office memorandum. That
Now,
union
state
petition,
has its
anything,
own
they have to
office,
serve the copy.
office of the advocate general. The central has its own office, the office of the DSP. Those can be given.
those are given. But when it comes to MCL,
Also, even a private,
yes, the MCL, what happens in your lordship, these PSUs like MCL or I mean,
it has to be.
even for example,
Let's see, it's correct. Kind of ministry law issue a circular that has the Union of India and the any PSU is there, the central government council will take care of. But they are program practice, their councils are appearing.
No, I'm just thinking because I come from a state where the rules contemplates that a writ petition cannot be filed nor be listed unless the copy of the writ petition is served upon the, we call it a respondents, not opposite party, upon the respondents, including the private respondent as well. You'll have to show that I have already sent a copy.
I am aware of that. I've
And
seen it.
48 hours notices to be given before listing.
But your lordship, unfortunately, we don't have it. You only give it to union and state
And this will avoid these kind of
problems.
We also are not receiving
Sometimes, of
copy
course,
from the Union
I say the union. I mean, Mr. Padi has always been kind that he sometimes sends it to the PSUs.
Well, you become sensible. You should have sent it prior.
Your lordship, as we
Very difficult.
With the PSU itself. What is there?
You could have.
yes.
What I'm saying, madam, let's keep it to Monday or Tuesday. I'll let them survey copy. I'll take it.
We are keeping it tomorrow.
Advance copy has been given.
You have been
Copy.
Advance copy. Then आपको advance copy नहीं. Advance copy has been given to his office. We'll serve another one. You no problem with that.
Not single one, the other one is actually error.
Or appearing on behalf of MCL, you have no issue.
No issue.
Okay.
Like
he always volunteers. But
They have a notification from the law department that if union and a PSU is party, then he will appear also for the PSU. But
There is a circular, but
But then
there
I
is no
also appear
practice
for-
that I am not
but-
insisting.
but then I do not know why. But I appear from some PSU.
considering the
Publish.
on Monday. Under the heading to be mentioned. So that it will be a.
Item 27.
Your lordship heard this matter on the 5th. This is the case where
Just You are in fact challenging the cancellation of the tender. At what stage?
They floated another tender.
No, at what stage? You are challenging that order of cancellation of the tender.
Cancellation of the tender, yes, Manoj.
Yes. That is primarily factor. If that goes, then automatically the
Second tender will go.
will also go.
And my bank guarantee,
That is you have to.
and the bank guarantee which has been encashed shall be restored. Because they have, what they are having cancelled the tender on administrative grounds, they have also encashed my bank guarantee.
How can they?
They have done it, and thereafter, they having realized the mistake, they wrote to the bank to hold the encashment, but by which time the bank had already remitted the money. So the bank wrote to them that kindly send back the money so that we can restore the bank guarantee. They are sitting quietly over that.
What are you doing? What are you doing?
Here we need to file a counter affidavit.
Need to file a counter affidavit in this regard. You have you not cancelled the tender? There is already an annexure 16.
Let they have filed an amendment application. Last page they will see the copy.
Sir, the difficulty is there are two aspects pending. Mr. Everybody consider. There was a tender floated by you. He participated in the said tender, gave a bank guarantee or whatever in the EMD or a security, whatever.
Insurance security.
Everything was given to him. Given by him to you. You decided to cancel the tender and floated the fresh tender. Once you cancel the tender, will you not return the bank guarantee or whatever the amount security or given? Rather, you invoke the bank guarantee. When you realize that this was wrongly invoked, you wrote to the bank not to send the money. This is what they say.
Yes.
And the bank by this time has already given you money. You say that don't send me your money. But the bank says that I have already sent the money. Will you not return that money to the bank? You want to give a counter?
These facts are not incorporated here. It should be incorporated.
It's there. In the amendment application. They happened after the writ petition was filed. So they are there in the amendment application. Your Lordship, your Lordship wanted them to take instructions by 6. They wanted time till 10th. Today we are on 12th.
Last occasion it was not given to us. In the meantime,
it was served when it was filed.
The party, if this is the fact, don't you realize that what is the obligation of the government?
We need to file a reply.
What is the reply you will file? Can you deny your letter to the bank that, sorry, it was a wrong invocation of the bank guarantee? Do not remit the amount to me. If this is your stand, and if the bank says that before we receive your letter, before the receipt of the letter, we have already remitted the money back, money to you. Please return it so that we will restore the bank guarantee. You will not pay back. Forget about the cancellation, forget about the first tender. Will you not return the money? Interesting. With authority, we are calling him to appear personally. This is the attitude how a citizen of the country will run his business.
Fix up a date to the next week.
No, we are directing. We are directing. Directing this remittance immediately.
Let's fix up the date next week.
No, why should we? Simply on your prayer that please fix it on the next day. When it is absolutely an open and shut case.
Let's see item 51, Madam.
We are not concerned with item 51. We are concerned with this. What they say, if it is correct. What they say, if it is correct, then what?
It is
what remains?
It is not correct.
Not correct.
No.
Have you not written a letter to the bank that please That was a wrong invocation of a bank guarantee. Please do not remit them out.
That is in some other circumstances. That's I need to.
I'm asking you, sir, have you withdrawn that letter? Tell me. Have you withdrawn that letter?
I do not have that instruction.
Then let them suffer. Which is the authority? Tell us.
That's one day only submit.
Let us.
Superintendent engineer, superintendent, superintending
It has been
engineer,
encashed by whom?
encashed by his superintending engineer, Marcona Canal Division, Marcona, opposite party number 3.
You are directing him to appear first. It is submitted by Mr.
Item 28.
28 is same. Absolutely same.
Same. They wrote a letter, bank guarantee involved.
Same. 28 and 51. Same. 3 parts. It was broken up into 3 parts. So the entire project
of the order pass in this item number 27.
51 million.
My previous work. Basic case Miller, the post selection, I was selected. I was directed to submit the additional performance security within a time bound manner, and it will be 30th Miller June 2026. 29 I prepared, bank also mail Miller, and I submitted the bank guarantee. But when they entered to the physical submission, some persons Miller in it available have taken stand CCTV footage, obstructed that not to allow to submit. And you also kindly see the letter. Then you also I lost a FIR police immediately because I am the lowest tenderer. Some all are quoted except me are scheduled rate, exact rate, trying to fix the tender process.
So trying to create a cartel.
Yes, your lordship. And they issue letter of acceptance. You deposit the earnest money. And last date is 30th June 2026. 29th is prepared. But when I enter into the office, some person prevented me. I wrote to the collector, superintending engineer, and local IIC. I taken understand there is a CCTV footage of the office. They are not allowed. Again on 30th, I go to the office, and they also I prevented me. And your lordship has a direct last time Mr. Tripathi as my learned friend was asserted they will take decision, but till date, Millard, they are not considering the my bid, Millard. And the is presence of the officer, your lordship.
Millard, it is a fact, Millard. But
who was the person? They want
members of the local contractor.
Yes, they hooligans.
Members.
Why the actions are not taken against them?
They are staging a dharana in front of the office. That
Dharana means preventing anybody to enter.
That is his allegation.
No, it's not allegation.
If it is a dharana, then you say that it is the correct one.
Millard, no, Millard.
So,
is registered, Millard.
No, nothing.
They might be.
Why don't you permit him to give a adequate police protection and let him go and deposit?
Yes,
we are extending the time.
Yes, I already submitted. Bank also some me bank guarantee.
Oh, you have in your
yes.
It is a valid one.
Yes.
The validity period has not gone.
No, yes.
Yes, they have not taken any step. It's the same. Yes, it is the office to submit the bank guarantee.
Yes, Lord. STDR, Lord.
Item 30.
Wait, please, Your Lordship. Your Lordship, a tender being floated in
The first tender.
I was selected in 2024.
No, that is there. And it was valid up to 31st of July. Now the 31st July. You have worked till 31st July?
Yes.
Yes, Your Lordship. I have worked till 31st of July.
Now, 3 months prior to 31st July, we have floated a tender and invited place tender.
Correct.
That he is challenging now. You should have given me extension for that.
No.
Sir, what is your right after the validity period?
Your Lordship may kindly see the request for proposal, that is annexure 1, page 34, Your Lordship may kindly.
I understand you were awarded the contract. The contract was valid till 31st of July 2026. Is it not?
No, Your Lordship.
Have you been prevented from discharging your contractual obligation up to 31st July 26?
No, Your Lordship, until 21st.
You went there. Now then, after the tenure, what is your right to continue?
Your Lordship, my right is in the tender itself, it says that this work is for 3 years. That is from 2024 to 2027. So my 1 more year remains, Your Lordship.
What are you talking about? It
Lordship,
says
may kindly see page
executed an
34.
agreement and which says until 31st of July. Why you entered into an agreement? You entered with the open eyes.
Your Lordship, that was the clause in the tender that each year
I am asking what?
Lordship, each year there will be a separate agreement extending for 1 year, and the total length of the tender would be 3 years. So for first 2 years, I have signed.
Where is that? Where is that?
Your Lordship, may kindly see page 34, Your Lordship.
Page
34, annexure 1, page 34. 34.
Yes.
Clause number 4.1, Your Lordship finds. The engagement of the service provider shall be for a period of 3 years from the date of signing of contract. However, the agreement with the service provider shall be signed initially for a period of 1 year from the date of signing of the contract, which shall be renewed on a yearly basis.
No, engagement is always 3 years, not beyond that, but it is on a yearly basis, subject to the satisfactory service. So, when the first contract was entered into?
Lordship, first contract is at annexure 3, page 49, that is 1st August 2024. And the same clause is also there at page 53, Your Lordship finds. The clause that was there in the RFP, the same clause has been verbatim quoted in the agreement also. Point number 7 at page 53, Your Lordship finds.
The initial contract will be from 1/8/24, 8 to 24.
1/8/2024 to 31/7/2025. And then, Your Lordship, annexure 4 is, Your Lordship, the next contract for the next period. There also at page 59, Your Lordship will find that for the second year, I got the renewal.
This is second, third was not a, there is no separate one.
Now, before this 31st of July, Your Lordship, they have terminated my contract and they have
not terminated. You continued up to 31st July.
Up to 31st, but as per the...
But after 31st, they have not renewed it.
They have not renewed it as per the award of contract.
They have not renewed it.
Lordship, as
So
per
you
the award
can't
of
say the
contract,
termination.
Your Lordship, for the award of contract says that it will be renewed for 2 years. That is annexure 2, page 46, Your Lordship finds.
After the expiry of the period of 1 year, 2 years has passed, and renewal has given. Thereafter, his service, of course, I have not received instruction with regard to performance, but his performance must have been good, therefore, based on the agreement right. Now, he is forced to say that I will continue for another 1 year, even if my performance is not satisfied.
No, there must be something which should be there in the writing.
With regard to that part, I have to offer instructions to that part. But there is
File affidavit within two weeks. Rejoinder 1 week. Matter to appear after 3 weeks.
Your Lordship, I at flag B, I have made an application to implement the successful bidder. I may be allowed, I'll file a consolidated cost action.
Successful bidder have been served.
No, Your Lordship, I'll file a IA.
No. Open number 2.
Who is he?
Number 2, action of the open number 3. National Health.
Who is
We are not made fun.
This is an application seeking
Obliged.
81.
31 made that 10.
Reduce the tender documents. As per the last order, my lord, your lordship was directed me to reduce the tender documents of all the participants. The tender documents are there, my lord. Only for one reason, my lord, because whether the financial bid has been opened or not. To that effect, my lord. There's a folder, orange flag which contains all the financial bids, is sealed.
Statement not been opened. So financial bids have not been opened. It has been rejected on the after the opening of the technical bid only, on the ground that due to lack of competition. Even though two tender participants were qualified at the technical.
What is that? Has it been opened?
The orange flag contains all the.
Exhausted. Matters are listed. Two person. Any
Clause 29. Regarding single tender, single bid.
Yes, which provision?
Clause 29.
29.
We allowed place.
This is not.
Yes. What is the where? What you are referring?
20.
Clause 29
Of
OPWD code volume 2.
Volume 2.
I do not find any clause.
That's to
No, I do not find any clause in volume 2.
It is.
No, it is a Odisha Public Works Department Code, volume 2. What are you referring?
29 months. Exactly, it is important.
Amendment in 2015. 53. Where's he reading? It is not there in our.
Amendment of income.
It is only one.
Single bid.
Not single bid.
It is not.
It is only when only one person submitted the tender. It is not that multiple persons submitted the tender and some of them were qualified, only one IMAS responsive.
Applicable in the present.
Yes.
It's not a works contract. It is not a works contract. As per clause 1.
Transport.
Yes, madam. It is applicable only in the OPWD is applicable only to works.
So which provision of OPW?
1.1.1, madam. OPWD volume 1, 1.1.1. It talks about where it is applicable.
One point.
1.2. First clause.
First clause.
Public works.
This is a tender for.
Only in irrigation, power, rural development, urban development department. Yes. And this is?
This is my love. It's a midday meal program.
Oh, transporter.
Yes, my love. It's applied school in mass, my love. School and mass.
This is a judgment of the Supreme Court. Is a old judgment. Where the Supreme Court very succinctly explained the concept of an open tender and a power of the tendering authority to cancel it in the event the participation is less.
In the
1988 Supreme Court, if my memory does not betray me.
Authority of India judgment.
Huh?
Might be the Airport Authority of India judgment.
1988.
Yes, I think my love, Airport Authority of India.
Show us.
There's also Nanda Infra full bench judgment of the full court judgment of this honorable court in Nanda Infra, where this honorable court has held that there's no vested right. In this case, the technical bid at the stage of technical bid only has been rejected.
No, he is qualified. He says the cancellation was not warranted because there were more than one bidder found successful. So that is what I'm saying. He is also found responsible.
Inadequate competition.
Yes, ma'am. It's here in Nanda in this court has held that before cancellation of rent, requirement of giving an opportunity.
Airport authority may be a judgment, which
Airport, yes, as far as I can-
88, if I correctly remember, I do not know, I have a very faint memory of that. Year, I do not know why my gut feeling says year is 1988.
And Raman Dayaram Setti versus Airport International Airport.
Dayaram Sethi, huh?
I'll just take it out from SCC now.
79.
79.
I do not know why 88 is coming in my mind. Make a Passover. In the meantime, you just write. Have you got the judgment?
Let me just read the judgment, whether it talks about the participation portion or not. I'll just get what the relevant right. On the judgment relates to tender matters. Only thing I have to see whether
You just find out and give those. There are. I remember only two judgments. One is the airport authority. I do not know the second one. I'm just. I am not in a position to remember the name, but I do not know whether it is a AIR 1988 Supreme Court is coming in my mind. I do not know. So let me, in the meantime, I will remember. Don't worry.
this judgment.
If it comes in my mind, I will give you a name.
Nanda infra may also be referred because it deals with all the.
I'm not aware of this.
Cancellation, full bench of this on the paper. These are all the judgments of from Tata Cellular to Jagdish Mandal.
Yes, I will go through it. There are many judgments.
The conclusion at para 43 answers the question.
I have a bad habit of reading the judgment which is cited there
Yes, ma'am.
before I proceed.
Here they have quoted from Tata Cellular till Jagdish Mandal of the government. I'll find out this document.
Yes, we are keeping it for orders. Keep it for orders on next Wednesday. In the meantime, you just give. Send this judgment and the file to me. Yes, call the next.
Item 32.
Item 32, my lord, next, your lordship. My lord, this matter relates to that tender, my lords, where the company had authorized the director, who in turn is to give an authority to a person, and in accordance with these clauses, the director had authorized Mr. Ghosh to sign the documents, and these were uploaded. So, my lords, basically the authorities have mistakenly, my lords, thought that the person has to be a real person, not a juristic person. That is the entire mistake that the Union of India has done.
Yes, juristic person is also a person.
My lord, I'm just clarifying what it is. Here is the case, let's me come to case 14. Clause number 2.1.5. I'm just reading. 2.1.5.
Correct.
May I read it?
Submit a power attorney format
as per the format of Appendix 2, Italian 2, authorizing the signatory of the bid of committee of the bidder. That is very what is authorizing of the signatory. Then let's see, come to page 59.
Page
59.
59.
59. And Excel one.
Yes.
I'm just reading my lord. This clause, let's see the
2.14.1.1.
Yes.
Yes, I am. Yes.
It is mandatory for all the bidders to have a class 3 digital signature certificate, DSC, in the name of authorized signatory, public the power or organization, public owner of the power or organization from any of the license certifying agency. Bidder can be seen in the list of licenses from the like such and to participate in tendering. DSC should be next. DSC should be in the name of the authorized signatory. This is very important. Authorized signatory as authorized in Appendix 2 of this RFP or person executing the delegating such Appendix 3 in favor of the authorized signatory. It should be in the corporate capacity, that is the bidder capacity in case of consortium or JV such and such. Then the bidder shall submit document in support of the class 3 DSC. In other case, the bidder shall be considered non-responsive. Then let's may come to the page 64. That is clause 3.1.6.
Yes.
Yes. Test of responsiveness. Let's may come to the 3.1.61. As the first steps towards evaluation of the technical bids, the authorities shall determine whether each technical bid is responsive to the requirements of the RFP. A technical bid shall be considered responsive only if A. The bid is received online as per the format at Appendix IA including the annexure 1, 2, 3, 4, 5, 6, and appendix 7, if applicable, and appendix IB. Then I am not going to the other points. Let's make the relevant point. D. The power of attorney is uploaded on e-procurement portal as specified in the clause 2.1.5. Then let's make the next claim. The technical bid is accompanied by power autonomy for the lead member of the consortium or joint venture or joint bidding agreement as specified in the clause 2.1.6 if so required. Then let's make, I'm just coming appendix 1. Before that, I'm just completing the F also. Technical bid contains all the information, complete in all respect. Then I'm coming to the, let's say, this page 89. Appendix 2, format of the power attorney for signing of the bid, page 89.
Yes.
Yes. This is the format is given. Then in that format, let's see after 4 line, as our true or lawful attorney, such and such, then his format is clarifying that what is our condition, precondition for formatting the same. Then let's see, I'm coming to the next page, 91. 91, appendix 3, what required by the format for power attorney for lead member of consortium or joint venture. Then there is a, then let's come to the second paragraph. Whereas it is necessary for the member of the consortium of the joint venture designated on one of them
as the lead member.
Is lead member with all necessary power and authority to do for and on behalf of the consortium joint venture all acts, deeds, and things as may be necessary in the connection with the such and such. Then I am coming to the 173 page. They have filed this. This is their document, my lord. Annexure 5. 173. May I read my lord? Page 173, Annexure 5.
Yes.
Yes. Let's make the first line in Chhattisgarh, then 24 January, then appendix 2. Then power of attorney for signing of bid. Refer the clause 2.1.5. According to the end of appendix 2, what I refer to, my lord. Accordingly, this was given the this is such the we Santi Engineering such and such the petitioner company do hereby irrevocably constitute, nominate, appointed, and authorized Mr. Saurabh Ghosh, son of such and such. Saurabh Ghosh name is coming by the partner. Then let's come to the next page, 175. Board resolution. Then their resolution I am not going through it. Then I am coming to the next page, 176.
Yes.
Clause 8 and 9 I am referring. Then board resolution is there, provided that notwithstanding anything herein before contained in the said attorney shall always act within and not outside the instructions or the directions received by him from the company, and I hereby agree to ratify all acts and things lawfully done by the said attorney pursuant to the power herein before continue. Then my lord 9, further it is resolved that Sri Rishu Agrawal, director of the company, is also authorized to delegate his power to any other persons for and on behalf of the company. The civilization right. Then let's see me come to the page 235. 235. This here, that is filed by the another person, that is Rahul Dev. That is first Santi Engineering Private Limited, page 235. There is a column wise tabulation is given by the East Coast Railway, and the name was Rahul Dudania, mail ID such and such, number is such and such, work in such and such. That's why we have filed the affidavit today. Paragraph 8 and 9, we have described all the people. So the railway authority is examining the same and found that the person whose name is nominated in the board of directors. The company itself.
Risu Agarwal.
Rishu Agarwal.
The director who has been authorized.
Yes. That is two documents they have given to the railway. One is power academy. They have given one name. Then the board of registration, they have given another. And he has been, the board of registration itself declaring that the particular person whom we are authorized to act for this tendering process, he will be acted on behalf of the company in all respects. But here what they have done, they have come in another person who is executing the document, who is differing from in the time of scrutiny for which he is rejected. Then let me see, then send 235 page, third column. See, page 235.
Yes.
About the Rahul Didania. This serial number is given, and Rahul Didania is email address. Everything is not the person whose name has been resolution was passed, and he has been given the document is given to the railway or acted upon on behalf of the company. So they are differing the appendix 1 and appendix 2, and they have come with and repent another person who has not been authorized with the company itself for executing the documents on before the.
Was he authorized by a Rishu Agarwal?
Yes, fellows, he has been authorized. There are two directors who have been authorized. Your lordships may see the board of the 186. Your lordships may kindly see. There are two persons. Fellows, I'll just explain why. Junjunwal. Did one here. When I
just let him complete.
As regard to their document, what they are in respect of the page 186, Rahul Didona, director, there is a board resolution, they have annexed in the document. It's fine. But it is not within the knowledge of the special way. How is that submitted? They are not submitted.
It is submitted online, fellows.
That's why I am filing a affidavit denying that the use of document is in filed before the authority.
It was filed, fellows.
Because it is one that 1/6/2023 they have resolved it. Resolution has passed. Because the previous one is the part was 24 January 2026. 24 January 2026. And it was 1/6/2023. This prior to this power attorney prior to this resolution of 1/6/2023. There is a two resolution. It's a board of resolution was 1/6/2023 11A. It is 1/6/2023 11A.
Yes, by one board resolution, I am authorizing.
Years back, then they are coming with the power attorney different. It is 2026. Appendix 2. This name was given. That Ghost.
But this was uploaded on the same day. Whether it was uploaded, both the board's resolution.
No, that's why
you said that You just read out that particular date. From which page you read out?
I am referencing page 173, Lordship.
173.
Yes.
This is executive. This is a power of attorney.
This is the power attorney.
This
executed by Shakti engineering.
Power attorney was referring to the clause 2.1.5. This for this tender. And the next 175 is the board resolution in respect to the present tender. That is in 2023. They have given a name that is Rahul Agrawal. And it's a Rishu Agrawal. Another same now they are coming. No, this document is not relying upon. We are relying upon the board of resolution. The same date, same time, another name.
My lord,
not operating.
Most probably he has been wrongly instructed. He has been going off at a time. 23, my lords. The board resolution was passed authorizing 3 directors, not only 2. Sorry, Rishu Agarwal, Rohit Agarwal, and Rahul Didwania. Authorized Rishu Agarwal director and Rahul Didwania in another. There are 2 sets of board resolutions. And my lords, I can only file the DSC of the firm. That is what is stipulated in the guidelines. So I filed.
No, that is what you are referring to. Page 175 is the
Yes,
board resolution.
Yes,
where the board of directors have taken a resolution to authorize Rishu Agarwal, one of the director, to act on behalf of the company.
Exactly.
It also confers power upon Rishu Agarwal to authorize any other person which will be deemed to be an action of the company. There is no difficulty.
Yes.
So now the question is that this document which was given is in the name of Rishu Agarwal.
But
now the document at page 235 shows that it is a Rahul Didwania who has submitted the bid.
Rahul Didwania, the company has submitted the bid.
Oh, signed by whom?
My lords, the digital signature is in the name of Rahul Didwania.
Correct. So now the Rahul Didwania signed it.
Yes. No, my lords, the DSC, your lordships may kindly see.
No, I have seen organization, company, everything is included. I know.
My lords, when I bid online, the DSC of the company has to be utilized. The DSC of the company, I'll just point out, just say the clause. Clause 4, if your lordship kindly sees, annexure 4. That is user guide for registration of new vendors contractors. It's at page 156.
Yes.
Yes. Now your lordships may kindly see 160 step 2. This is the registration process. Click on the DSC of your firm to select the same and then click on select button. This will open the registration interface. Now, if I don't click on the DSC of my firm, the DSC stands in the name of Rahul Didwania. So the firm's DSC has to be utilized while opening my portal in the online registration process, which I have done, my lords. And it cannot be changed subsequently, my lords. It is also written, my lords, that page, if your lordship takes up 160 in the online, this thing, 160. So also clarify.
Yes.
Yes, I'm just pointing out what is clarified. This is important. The name of the firm has been picked from your digital signing certificate, and the same cannot be edited or altered. Page 160. 160.
Just below the step 2.
Step 2, there is a column, my lords. Name of entity, important. Name of firm has been picked from your DSC, digital signing signature, and the same cannot be edited. If your lordship sees it in that, my lords, in the uploaded writ application,
I got it.
Be clear.
Yes.
So once we sign in with the DSC is in the name of the firm represented by Rahul Didwania. That DSC goes on. Now, the company who ultimately is the bidder, it is not Didwania or my lord's Rishu Agarwal. It is the company who is the bidder. It has authorized two directors to act on behalf of the company, and that there is no embargo. In fact, the clause 2.14.1, which basing on which they have cancelled my tender, clearly stipulates it is mandatory for, if your lordship again kindly takes up 2.14.1.1. It is mandatory for all the bidders to have class 3 digital signature certificate, which I have. In the name of the authorized signatory, former organization, owner of the former organization from any of the licensed certifying agencies. Bidders can see the list of CS from the, that's okay. DSC should be in the name of the authorized signatory as authorized in Appendix 2 of this RFP, or, my lords, it's a disjunctive clause, or person executing, delegating such Appendix 3 in favor of authorized signatory. It should be in corporate capacity, that is in bidder capacity in case of consortium, JB in the lead member capacity, as applicable. The bidder shall submit document. Now, who is the bidder, my lord? Shanti Engineering is the bidder. It is not Rishu Agarwal, nor is it this Junjunwala, Nadidwania. They are not the bidders. The company is the bidder. And your lordship, Appendix 3, your lordship may kindly see. They find me also qualified. The Appendix 3, page 177. Annex 6. Lordship gets it. Page 177, Annex 6.
Yes.
My lords, now therefore know all men by these presents.
Yes.
Now therefore know all men by these presents, we, Shanti Engineering Com Private Limited, from our head office at plot number such and such, and Limited Liability Company Sphere, having a registered office at 45 Pushkin Street, Chhattisgarh, room 14, UFA, Republic of Russian Federation, and having its local office at such and such, collectively know here referred to as the principals, do hereby irrevocably designate, nominate, constitute, appoint, and authorize Shanti Engineering Private Limited, having head office, being one of the members of the joint venture, as the lead member. So who's the lead member? Shanti Engineering is the lead member. It is not Rishu Agarwal nor Rahul Didwania, my lords. The very basic tenets of corporate law they fail to understand, my lords. This is
they're forgetting the word consortium.
Consortium, my lord.
Yes.
I am the lead member. Shanti Engineering has been designated as the lead member. Shanti Engineering, my lords, tenders. And Shanti Engineering does it in the name of Mr. Saurav Ghosh. Saurav Ghosh is authorized by Rishu Agarwal, who has been authorized by me. And we also say that all acts done by Mr. person who is nominated by by Rishu Agarwal is binding upon me. So it's not a question of Didwania or Rishu Agarwal. Whether my power of attorney delegates the power correctly to Mr. Ghosh or not, that is the question. And they have given some counter, I think, affidavit or something.
You have submitted paragraph 8 and 9, very relevant. Let my friends, we are confined to two documents. One is Appendix 2 and one is Appendix 3. The Appendix 2 confirms that this person is not being name is there. Then Appendix 3 will come the next step. Also, so there is not within the knowledge of the person who is applied before the review. He is new in picture, even though accepted that he is a director. We are not disputing this. He may be a director. You may be a managing director of the company. But why concerned to the railway? Railway is concerned to Appendix 2, Appendix 3. Those are authorized, then he will say execute document and he will give single.
And who's
whatever
the
document he will give. Because
There is not, that is what they failed
this
to understand.
prerogative is given to you.
What
You
is
gave on this.
what is the stage of the tender?
It is finalized, it's given to already, OP number 5 has given, whatever is.
Party mark.
Has it been served or
Notice has not been served, I'll take notice.
take notice?
Question.
You gave by speed post, we are directing. The petitioner is directed to serve the copy of the
NIT letter
of the
of
petition.
acceptance for the issue by the railway.
You have already filed an affidavit.
Yes.
The petitioner is directed to serve the copy of the writ petition upon opposite party number.
May I pray for interim statement?
What stay? The work has already been awarded, everything has been done.
Started, they have just.
No, no.
Subject